Good afternoon, everyone. Thank you very much for joining us in the latest of the 39 Essex webinars. My name's Colin McCall. I'm told that whatever this means, my bandwidth isn't very much, for which I apologize, but I'm told if I don't move too much, I should be clearer. My role is principally to introduce the two speakers today and the topics that they're going to talk about. In addition, I've been asked to voice a couple of thoughts about when and how arbitration works in the sort of cases that we anticipate many or most of you will be involved in. First, a brief word about questions that may arise. Given time constraints and profiting from a steep learning curve as to what works best on these platforms, rather than to seek to deal with questions online, could we ask you please to send any questions that you may have by email to any one of us. That's firstname.surname@39essex.com. And we'll put out a piece anonymizing the questions, or questionnaires, I should say, and setting out our answers. So turning then to the theme of this webinar, it's fair to say that COVID-19 has forced all of us to do things both in our personal and business life in different ways, what I suppose has been termed the new norm. Most of us will be disappointed to have read that emissions in China are now back at their pre-lockdown level. And on a personal level, the jury's still out as to whether my wife will continue to cut my hair. But lines for voting will open in a couple of minutes on that topic. But anyway, in this webinar, our speakers are going to look at two of the major repercussions of COVID-19 in the world of litigation. And both of those repercussions, we are confident, are likely to remain permanent in the new norm. Now, the first of those repercussions is the time which a claim is now going to take to get to final hearing. And the substantial delays that parties face, the resolution of a claim brought in the courts, will prompt many representatives to give much closer consideration to ADR than perhaps they have done to date. So in her presentation, Samantha Jones is going to review the magnitude of the delays in the court, remind us and update us as to the duty we're all under to explore ADR, and then to look at the substantial benefits that are be gained from using arbitration as a means of ADR. Samantha's got significant experience in civil litigation with a particular focus on personal injury, clinical negligence, and costs acting for both claimants and defendants. She'll then be followed by Robert Lazarus, who in the first part of his talk is going to take us through the role that the courts play in relation to arbitrations in terms of giving muscle when needed to the arbitration process, the enforcement of an arbitration award, and the scope for a party to apply to the court to seek to upset an arbitration award. Robert practices in professional discipline, professional negligence, clinical negligence, personal injury inquests, product liability and insurance law. He sits as a recorder and as a co-editor of the clinical negligence product liability chapters in Bullen and Leak. I should tell you that prior to being called to the bar, he practiced medicine up to the level of an NHS consultant. So if you want a free consultation, now's your chance to ping an email to Robert. Following that, I shall say my few words about arbitration in practice. And thereafter, Robert will give the second part of his talk. And he'll be dealing with the second of the major repercussions of COVID-19 felt by litigators, namely the mass utilization of electronic bundles. Now, when the question of electronic bundles emerged here with COVID-19, Charles Manzoni, QC in our chambers, pointed out that in Hong Kong, he hadn't done a trial with paper bundles for the last 5 years. So no one can doubt, I suggest, that litigation in the UK will henceforth be conducted in the same way, and that paper bundles will be permanently consigned to the dustbin for all but a handful of cases. Robert, who, believe me, is no slouch in the world of IT, will be giving very useful advice as to the compilation of electronic bundles. So that said, can I now hand you over to the first of our speakers, Samantha Jones.
Thanks very much, Colin. Good afternoon, everyone. So as Colin has said, I'm going to be running through with you looking at the COVID-19 delays in the courts, which are probably all very familiar to us now, and then looking at why you should even think about doing ADR, and then looking at the principles and procedures of arbitration in a brief summary. So first of all, something that I know that we're all familiar with is is the delays in the court as a result of the pandemic. It started, of course, just before the lockdown was instituted, 17th of March 2020. The Lord Chief Justice issued the statement I've put on the slide there, which is that COVID-19 will clearly have an impact on the operation of all courts in every jurisdiction. It's not realistic to suppose that it will be business as usual in any jurisdiction, but it is of vital importance that the administration of justice does not grind to a halt. And as no doubt you will have seen, the courts have really tried to do everything they can to ensure that hearings are running, but really it's looking at urgent matters and ones that are in the public interest. Some of you may or may not know that the courts actually now have a court and tribunal tracker, which gives you updates as to which courts are open, how many are suspended. So as of last Monday, there were 159 open courts, 68 suspended, and that covers all of the courts and tribunals. So it's been a massive sea change, as no doubt many of you are aware, with your cases having been adjourned at the last minute. As you also know, the court service has been trying to now commence video platform for remote hearings, using Skype for hearings, and also trying to use more of the use of telephone hearings as well. Something that I thought would be helpful to look at is just briefly the county court listing priorities. It's probably a document you're all familiar with, but it's updated regularly, and this is the one from the 11th of May 2020. What this really does is emphasize how much the low value claims, your small claims, your fast track trials, are really being pushed completely out of the list at the moment. If we just look at the county court listing priorities, we can see that in the priority 1 category, they've listed what work must be done. And as you can see there, running your eye down the list, there are no trials, no small track, no fast track trials listed there. In your priority 2 category of work that could be done, we do have some of the low value cases, but it's a small amount. We've got the incident protected party approvals are still potentially going ahead. Stage 3 assessment of damages, so our MOJ stage 3 hearings, they're still going ahead. And then there are small claims and fast track trials where parties agree it's urgent and that is subject to triage. So in the majority of cases, you have a very little kind of avenue at the moment for your low value trials to get underway because they're just not being prioritized. Something else that the court service has said about prioritization of hearings is they said that all our courts and tribunals will hear matters relating to urgent and vitally important issues such as the deprivation of liberty, public safety, and individuals' rights and welfare. Hearings related to such issues will always be prioritised. Now, that is fantastic news, but you can all well imagine that our average slip and trip in Tesco's or our road traffic accident probably doesn't quite meet that criteria. So this is why we are looking at alternative dispute resolution, particularly at this time. Something else I just wanted to make you aware of is, of course, the regional guidance that's also being issued, just to give you a flavour of what's happening in the regional courts. And really the picture is that, as you've probably all experienced already, small claims track, fast track trials and multi-track trials were pretty much all vacated and looking to be relisted when the lockdown started. So, for example, the designated civil judge for North and West Yorkshire Registry, Mark Gosnell, issued guidance on the 23rd of March and the 4th of April, basically saying that they would have to vacate and relist all small claims track hearings. The block lists, you know, the ones we're all very familiar with, particularly to kind of churn through the low value fast track trials. He said that those may need to be given separate times for their hearings rather than blocks that we were used to. And of course, we all know that that must mean it will lead to fewer cases being dealt with a day by a court. He said that they would initially have to vacate all of the fast track and multi-track trials, and that all users of the court system would be given the option to decide if they would like their hearing to be heard on the papers, whether they would like for their hearing to be held remotely, or whether they would like their hearing to be adjourned until it was safe to have a face-to-face hearing. What it was recognised in that guidance, this is the one that was issued on the 23rd of March 2020, was that he anticipated that there was certainly a number of cases where it was just unlikely that parties were going to want to either do it on the papers or have it heard remotely. And the examples that he gave were the cases where you've got witness evidence that's disputed. He said he thought that that would be unlikely to be suitable for anything but a face-to-face hearing, of course, because there's credibility issues are often having to be examined. And he said that really he expected that many takers of remote hearings would be those ones where really what was in dispute was not necessarily witness evidence, but the dispute could be decided based on the construction of the documents. In his updated guidance of the 4th of April, he stated that the courts were trying to list some trials, you know, particularly by remote hearings, and he suggested that perhaps simple road traffic accidents could be done. But again, the option was being given to the parties, and he was saying, he said in that guidance that he didn't envisage that many people would take up the option of their road traffic accident claim even being heard by remote access. And we have a similar picture looking across the other district registries as well. Same thing in Birmingham, they vacated all of their small claims and fast track trials up to the 29th of May. Central London, Wandsworth, same thing, at the beginning of lockdown, they adjourned all of their face-to-face hearings. So in summary, it is a bit of a bleak picture when it comes to looking at how we're going to get these low value claims resolved in any like the immediate future. So then looking at why should we use ADR? The first thing really to say is that, as many of you will be aware, there have been quite a number of judicial pronouncements in, you know, the last decade or more, I would say, which is really encouraging parties to use alternative dispute resolution methods to try to settle their claim. And you've got the obvious points that the judges will always make. It's about saving costs, it's about saving court resources. But Sir Geoffrey Voss's pronouncement in the Petrom and Glencore case, which I put up there, I think is pretty emphatic, and it's something that certainly the practitioners' texts come back to. And I won't read it out, but the simple points are that parties shouldn't just be litigating cases for the sake of it and because they can afford it. Parties need to be thinking about the wider implications of doing so, particularly on our stretched court resources. And it's really, he really said there that in fact, you know, courts need to look at imposing sanctions where parties have been unreasonable in not using a method of ADR. But in terms of the kind of key highlights as to why you would use ADR in the first place, apart from that, is the 3 bullet points I put there on the slide. Now, I'm sorry that it slightly looks like I've taken a page out of the government's book when they issued their coronavirus slogans. It's avoid delay, save costs, and avoid cost consequences. No intention to sound like Boris Johnson there meant at all. But those are the key highlights. Before I just come on to those points briefly, what I wanted to do was also just bring up the PreAction Protocol and personal injury claims and just kind of re-emphasize what it says there. It's something that we'll all be very familiar with. I have to confess that until I went back to look at it for the purposes of this talk, I actually hadn't realized how emphatic it is about how much parties should be considering and using ADR, but it is expressed in fairly emphatic terms. If you can see in the first paragraph there, you know, litigation should be a last resort. And then in 9.1.3, the paragraph says there, if proceedings are issued, the parties may be required by the court to provide evidence that ADR has been considered, and that unreasonable refusal to consider ADR will be taken into account by the court when determining costs. And this, I think, just reflects what I was saying earlier, that there has just been such a move to make sure that parties are looking at ADR. And this is the stick to use to assist that. So just looking at avoiding delay. So obviously we've got the anecdotal points and the points I've already raised about the delays that we're all suffering at the moment. What I thought might be interesting is just to look at some of the statistics that actually came out of Lord Justice Briggs's review of the civil courts structure in July 2016. And there on the slide, I put some figures of how long it takes on average for cases to be concluded outside of the pandemic. So we've got 36,000 hearings being heard in 1 year. Those are small claims track hearings, 12,000 fast track hearings. And in terms of how many cases are reaching hearings within the 30 weeks and the 50 weeks prescribed in the rules, you've got just under 70% of the cases reach hearings within those timeframes on both tracks. But I have to say, when you look at the actual, the regional statistics, in some regions, and perhaps a number of you are familiar with this already, cases are, a number of cases are not getting to final hearing within 30 weeks or 50 weeks. I think it was in Leicestershire and Northampton region that less than 50% of cases were reaching a final hearing within the prescribed time frame. So it's something that we're all familiar with. It takes a long time for these cases to get resolved, and that can be frustrating when you have a plethora of low value cases sitting on your desk, on your file. What struck me in his report, in Lord Justice Briggs's report, was he found from his research that there had been such underinvestment in the provision of the civil justice service outside of London that he said it had now reached a critical stage, and that there was just a wholly inadequate provision of circuit judges for civil work. So again, something we all know, but I hadn't actually appreciated how serious it had got, and that was even before we came into these exceptional times. So just the general point about saving costs, here what I wanted to just emphasize was that ADR can be a really useful tool if you choose the right time in your dispute to commence it. It can be inexpensive if it's deployed early, if there's a good time, perhaps when some or all of the issues have crystallized in the case. And I think the important thing to remember, and the important thing that you'll see from some of the cases I'm going to talk about in a moment, is that the courts are very keen that parties, if they can, at least try to resolve some element of their case. So perhaps quantum where liability is in dispute, because even resolving some aspects of the case will save costs in preparation, costs in terms of the time used in court, and then ultimately reducing the amount of work that has to be done during the hearing. So then avoiding cost consequences, obviously this is what we're all acutely keen to avoid when we come to preparing our cases, and I know that that's often at the forefront of assessing prospects and whether we should be going forward with it. But just some important things to emphasize when looking at ADR. So there has recently been further judicial support, as if there couldn't be enough, further judicial support for the development of ADR. It was in the ADR working group's final report, which was issued in December 2018. And in that report, what they actually proposed as a recommendation was to have earlier and more stringent encouragement of ADR in case management. It said that there should be a perception that formal ADR must be attempted before a trial can be made available. We should explore the possibility of applying sanctions for unreasonable conduct that make sense at the interim stage. So that's quite a sea change, instead of waiting until the end of the case. And that's certainly something that's, I think, still being considered. One thing that then has come out recently is the two recent High Court decisions I put at the bottom of the slide. And these really emphasize how the courts are now looking at UNGLI orders. Now, UNGLI orders, for those who are not familiar with them, are often used in clinical negligence cases, devised by Master UNGLI himself. And essentially they are standard provisions in directions orders, where, as you're all familiar with, it will say the party shall consider whether the case is capable of resolution by ADR. If any party considers that the case is unsuitable for resolution by ADR, that party shall be prepared to justify that decision at the conclusion of the trial, should the judge consider that such means of resolution were appropriate when he's considering the appropriate cost order to make. And what it goes on to do in this standard form of wording is also to impose on the party who considers that it is unsuitable to go to ADR. It says that they must file a witness statement with the court not less than 28 days before the commencement of the trial, to give reasons as to why they thought the case was unsuitable to be considered by ADR, or with the ADR. So quite a sort of novel, strict way to make sure that parties are really focusing their minds on ADR. And what's interesting is that in the Housey case, it's a case from 2004, so it is some time ago now, but in the Housey case, Lord Justice Dyson said that essentially they saw no reason why those UNGLI orders should not be used in general personal injury litigation across the board. Now, you'll have your own experiences of whether those are being routinely included in your personal injury actions, but it's something to be mindful of. And if you are in a situation where you're looking at what a court will consider when looking at unreasonable behaviour on the part of the party not to institute ADR, you'll want to look at paragraph 16 of Housey, because the Court of Appeal there sets out very useful factors that will be taken into consideration. But the reason this is particularly recently interesting is the two cases that I've cited at the bottom of the slide. In both of those cases, the court gave that standard direction, and the parties had to file witness statements to explain why they didn't think ADR was suitable. And in both of those cases, the defendants refused to mediate, essentially because they were both separately confident about their prospects of success. In the latter case, in the Blackpool Football Club case, they did file a witness statement. The defendant didn't file a witness statement in the Watchtower case, essentially saying that they believed a JSM would not achieve anything because they had a strong defence. In both cases, the High Court judges took short shrift of this argument and awarded the claimants indemnity costs. In the Watchtower case, Mr. Justice Chamberlain stated that the parties could have had a JSM to at least consider quantum and settle that, so as to avoid the length of trial and questions to the claimant. So really interesting recent examples. Both cases are being appealed, so you'll want to keep an eye on those to see how the Court of Appeal deals with that approach, but it might be another sea change as to really forcing parties to really consider ADR, and who knows, it might be affected by the current climate as well. So then turning to arbitration, now I don't know about many of you, but my knowledge of arbitration, certainly before I started work on it in chambers, was probably about a half an hour lecture from my bar course many years ago. So what we were hoping to do with this is just to run through some of the basic principles that we think will kind of give you an insight into how arbitration works and the differences with the court process. The reason why at 39 we've decided that we would commence the 39 Essex arbitration scheme is really because we thought arbitration was really suitable for these low value cases. And the reason for that is because it is speedy. It can help parties to achieve a final resolution of their case. It is inexpensive, and the real benefit is it can be easily facilitated either by an arbitrator looking at the case on the papers or by way of a remote hearing. You may think that doing a mediation or a JSM might be a bit trickier with the remote hearings and the stay alert guidance that we're all having to follow at the moment. So that's why we've kind of picked arbitration as really the means for resolving low value disputes at this point in time. So just to give you an overview of the process, therefore, what is arbitration? So it's a process used by the agreement of the parties to have a dispute resolved with binding effect by a person or persons acting in a judicial manner in private. In the UK, it's governed by the Arbitration Act 1996, and it's helpful to look at the Section 1 of the Arbitration Act, which sets out the principles of arbitration. And this really just kind of hits home as to its objects. And there it says, the object of arbitration is to obtain the fair resolution of disputes by an impartial tribunal without unnecessary delay or expense. And the parties should be free to agree how their disputes are resolved, subject only to such safeguards as are necessary in the public interest. The key thing really with arbitration is that it is a consensual process. The parties enter into a contract to arbitrate. So the basis of arbitration is contractual. The agreement that the parties make about what they want the arbitrator to consider is absolutely essential. But in that agreement, what you will do is you will put forward the terms of your dispute. So it will be liability in respect of, insert accident, or it will be quantum in respect of general damages and special damages. It can be as full as you like, but enough so that the arbitrator clearly understands what is to be determined, and the parties must agree on that as well. The benefits of arbitration is that there is a lot of flexibility, and the parties can ultimately choose how they run the process. And the benefit of that is that hopefully anyway, parties will come away feeling as though they've had a fair hearing, but also it's a speedy way to make sure that your hearing is actually, your matter is actually heard and finally resolved quickly. So the things that the parties can do, they can choose the seat of the arbitration, so that's the country in where the arbitration is rooted. They can choose the rules which govern the procedure. They can choose who their arbitrator is, and some of you might think that that's a key difference between arbitration and the court process, where who knows what judge you're going to get sometimes. The parties can also choose the substantive law which governs the dispute. Now, for your low value sort of simple RTAs, those matters might all be actually fairly straightforward for you to have to consider. And in the 39 Essex scheme, if you were to choose that as one of your examples, we've set out there a standard model for how you might want to go about bringing your case to arbitration, but that can be amended based on your needs and what you want to achieve. The benefit of the process is that there's flexibility. The proceedings themselves, so the hearing is actually in private, so it's confidential, again, distinct from the court's process where your decisions could possibly be reported. The award, the decision on the merits of the dispute is final, so it is a binding award, it's widely enforceable. And another benefit you may think is that it's not subject to appeal. So Robert will go through this in a moment, but the award can't be appealed, although it may be set aside by a court in a number of exceptional circumstances. But that's quite a key difference, and what you may think is that that is fantastic for certainty and to achieve, like I've said earlier, finality to your litigation. If the parties reach a settlement and agree terms before the arbitrator actually has the chance to decide on the case, then the terms of that settlement can be incorporated into the award, and that can then help you to facilitate enforcement of the award if that's necessary. Those awards are known as agreed awards or awards by consent. So then coming to my last slide, just some matters that I set out from the Arbitration Act there for the first 2 bullet points, but it's that the arbitral tribunal will decide all procedural and evidential matters subject to the rights of the parties to agree any matter, and that's in section 34. So that's just reiterating what I've said earlier, really, is that the parties are free to decide on how they want to approach all of the matters that will arise in the arbitration. So disclosure, submissions, whether the strict rules of evidence should apply, that is open to agreement between the parties. But obviously, ultimately, if there's a dispute, the arbitral tribunal, the arbitrator has the ultimate say. Section 40, parties are under a general duty to do all things necessary for the proper and expeditious conduct of the arbitral proceedings. I've added that in there because it's just to emphasize that the purpose of arbitration is to ensure that parties actually work together to facilitate a quick resolution of the case. And that surely is a real benefit, not only in these times, but you know, we all know how frustrating it is waiting and waiting and waiting for a court to bring on your case to a final hearing, only to get to court or get to the day before and they've adjourned it for lack of court time or lack of judges, or, you know, even worse, that happening on the day when you get there. So this is the benefit, and section 40 of the Act really emphasises how important it is that parties work together expeditiously. And then finally, then just looking at the cost of the arbitration. So one of the benefits is that the costs of the arbitration will be agreed upfront. So that's the cost of the arbitrator. Parties are jointly and severally liable for the costs of the arbitrator, but as I said there, with liability for such costs as between the parties to be decided by the arbitral tribunal. And it's really the same as what you all know, is that the arbitrator will decide on the dispute, and then they will also decide on costs as well, just in the same way as a judge would in a hearing. So that's kind of it in a nutshell, really. There'll be a lot of questions, no doubt, about how this would apply specifically to perhaps your low value claim, and I would encourage you to certainly email us with your questions, and if anyone wants to see a copy of the agreement, we'd be happy to share it, just so you can see how it might work in practice. Okay, well, I will now pass over to Robert. Thank you ever so much for listening. It's been a pleasure.
Thank you very much, Sam, for that very helpful talk. As Sam explained, I'm going to be dealing with the role of the court in arbitration. And there are a few key messages which you need to keep at the front of your mind always in relation to arbitration. The first is that arbitration is a contractual matter. It's an agreement between the parties as to how their dispute will be resolved, and the court will always respect that agreement. And obviously, you've heard reference to arbitral hearings, but of course, that's merely an option which the parties can select. The parties can equally agree to have their case arbitrated in a different way. For example, if the parties think that it is suitable, by way of written submissions only, and have the case decided by the arbitrator on the papers. In terms of the actual involvement in the court, ultimately, if the court becomes involved, if an application is made to the court and there is a court process, realistically, one can view the arbitration as having failed, because the point about limiting costs and reducing delay will have been, as it were, obliterated once the court becomes involved. And therefore, it's very important to keep in mind what the powers of the court are and to work constructively with the arbitration process to avoid the court becoming involved. The other key message, and this can't be stressed strongly enough, is that you need to be clear in terms of the agreement about what you want to be decided by the arbitrator. That is crucial because if the arbitrator is encouraged after the agreement to determine matters which are not agreed between the party as matters for the arbitrator to deal with, that can result in a challenge to the arbitral award. So first of all, I just want to put up a scenario which I suspect many of you are familiar with, and that is a case in which a claimant is injured in a road traffic accident, and the defendant driver disappears from the litigation scene, as it were, and doesn't play any meaningful part in the dispute. And in the circumstances, the pedestrian also sues the insurer. And what would happen if that case came to arbitration? And I'm sure you're all familiar with Section 151 of the Road Traffic Act and the circumstances under which insurers are under an obligation to satisfy judgments. And one can see immediately that in Section 1511, that the section applies where there has been a judgment. And the problem here is that if one takes a dispute to arbitration, the arbitrator can only deal with issues agreed between the parties. And if the defendant driver is playing no part in the proceedings, you're going to end up with an arbitration that is entered into by an insurer and a claimant. And in those circumstances, the arbitrator cannot determine liability of an absent defendant driver who hasn't signed the arbitration agreement. And that is, of course, different to the situation in courts, which is where one serves a claim form on the driver who then chooses not to attend. The court is free to dispose of the claim in whatever way the court considers appropriate in the absence of that defendant. That doesn't mean that a case like this cannot be resolved by arbitration, but one needs to be very clear about reaching an understanding between the claimant and the insurer about how the arbitrator's decision about the accident itself is going to ultimately bind the insurer. And perhaps in these circumstances, it may be better to frame the claim under the European regulations, which give a direct right of action against the insurer, which is not contingent upon a judgment being obtained against the driver. having put this slide up, I'm not going to go into the realms of how Brexit may in due course affect this particular regulation, although there's no indication that the government is seeking to repeal this particular provision. So moving on now to the practical involvement in the courts. And you will see, first of all, that under Section 42, the court has the power to enforce peremptory orders of the tribunal. Now, immediately one reaches the conclusion that if one is in the face of having to do this, the arbitration may well have failed to achieve its point in saving costs. It's important that both parties go into arbitration willingly and are content to accept the decisions of the arbitrator, both in terms of the final award, but also in terms of any orders made in the course of the arbitral proceedings. And the importance here of Section 42 is not so much that one might actually want to invoke this in order to enforce an order, but rather that it acts as a reminder to parties that if they don't comply with the orders of the tribunal, they might find themselves before the court with the cost consequences that follows. So far as the practicalities of this provision involve, this can be either an application from a party to the proceedings or an application direct to the court by the tribunal. The key issue is that all arbitral processes must have been exhausted. The provision states that the court shall not act unless it's satisfied that the applicant has exhausted any available arbitral process in respect of failure to comply with the tribunal's order. The other key part of this, and this is something that will feature in other aspects of the court's powers, is that the parties may agree to exclude the jurisdiction of the court in terms of Section 42. The next issue I want to deal with, and you will see that I am to a certain extent just working through the provisions of the Act chronologically, is the power under Section 43 to secure the attendance of a witness. And you will see there that parties to an arbitration may invoke the same procedures as are available in court proceedings to secure the attendance of a witness. The obtaining of a witness summons from the court can only be with either the permission of the tribunal or the agreement of both parties. But clearly, if one is moving to a hearing with evidence and there is a third party witness that is crucial to the case, then just as in court proceedings, it is possible to obtain that the witness attends. And finally, and again, this is very important, as Samantha alluded to, awards made by the arbitral tribunal are enforceable. And these are enforced in exactly the same manner as a judgment or order of the court. What is significant here is this final point. And that is that enforcement may be challenged on the basis that the tribunal lacked jurisdiction. And you'll recall at the start of this talk, I referred to the importance of making sure that you are clear about what you want the arbitrator to determine, because the key area in which it is possible to challenge the jurisdiction of the tribunal is where the tribunal goes on to determine a matter that was not in the arbitral agreement as an issue to be determined. Interestingly, and again, I'll come to this shortly, a party may also lose the opportunity to challenge the jurisdiction of the arbitrator. And I will turn to that very shortly. And so there are three key bases on which an award can be challenged by a party at court. The first, which I've already alluded to a bit, is substantive jurisdiction. The second is serious irregularity. And the third is an appeal on a point of law. Before an award can be challenged, it is necessary to exhaust any process of challenge which exists within the arbitral proceedings. Much like an appeal, there is a tight deadline for mounting a challenge. Such a challenge has to be made within 28 days of the award. And finally, as you can see there, if the tribunal has failed to provide sufficient clarity as to its reasoning, then the court may order the tribunal to provide additional reasons. And so we turn first of all to the substantive jurisdiction. And when we talk about an appeal on substantive jurisdiction, we are mostly considering the tribunal determining matters which it was not agreed at the outset that the tribunal would determine. Now, whilst such a challenge is going ahead, the arbitral tribunal may, if the matter isn't fully concluded, continue with the arbitral proceedings and make a further award while an application to the court is pending. Notably, and this is very significant, a party may lose the right of challenge if it takes part in arbitral proceedings without making an application promptly, and the provision is that a party may not raise objection later before the tribunal or the court unless he shows that at the time he took part or continued to take part in the proceedings, he did not know and could not with reasonable diligence have discovered the grounds for his objection. And so there you have an important issue, that if parties identify that the proceedings have taken a tack that they do not think they've agreed to, then if they don't challenge promptly, they will lose the right to challenge. The serious irregularity, well, it's unsurprising that a serious irregularity could form grounds for challenge. It's really a situation where one is incumbent upon relying on the arbitral tribunal to, as it were, do their job properly. And you'll see there that one of the forms of irregularity which can be challenged is a failure to comply with the Section 33 duty, and that is the tribunal shall act fairly and impartially as between the parties, giving each party a reasonable opportunity of putting his case and dealing with that of his opponent, and adopt procedures suitable to the circumstances of the particular case, avoiding unnecessary delay or expense, so as to provide a fair means for the resolution of the matters falling to be determined. Equally, a serious irregularity could be exceeding the tribunal's powers, not conducting the proceedings in accordance with the procedure agreed by the party, failure to deal with all the issues or uncertainty or ambiguity as to the effect of the award. And if a serious irregularity is identified by the court can remit the award to the tribunal for reconsideration, set aside the award, or declare the award to be of no effect. And the final grounds of appeal, or grounds of challenge, I should say rather, is on a point of law. This is perhaps the ground of challenge which most significantly aligns itself with an appeal from a court decision. And what is notable about this provision is that a right of appeal on a point of law may be excluded by agreement of the parties, and often arbitral agreements have that exclusion as a way of limiting costs and giving finality to a case. Even if that isn't excluded, an appeal on this point is only with the agreement of the parties, which in most cases is unlikely to occur, or with the leave of the court. And moving on, the court will only grant such leave if the determination of the question will substantially affect the rights of one or more parties, and the question is one which the tribunal was asked to determine, and on the basis of the findings of fact in the award, the decision of the tribunal on the question in point is obviously wrong, or the question is one of general public importance and the decision of the tribunal is open to serious doubt. And despite agreement of the parties to resolve the matter by arbitration, it is just and proper in all the circumstances for the court to determine the question. So you will see there in very clear terms that when the parties choose not to exclude a challenge on a point of law, the courts have the permission, the leave process makes mounting such a challenge very difficult, and that underscores the whole point of arbitration, which is a private process which is expeditious and economic and occurs in private without the involvement of the court. So thank you very much indeed.
Thank you, Robert. Hopefully I'm back on. Yes. Okay. Thanks very much, Robert. Arbitration. Once and perhaps still thought by many practitioners as a bit of a mystery, confined to a somewhat rarefied atmosphere, inhabited by international companies who are having a bit of a tiff about oil or shipping, or perhaps in the sort of somewhat less rarefied atmosphere of the sort of penultimate T&C in a package holiday contract, setting out what would happen in a dispute about a non-existent swimming pool. In fact, as you've heard from Sam, arbitration is a remarkably simple and effective way of resolving any legal dispute. The rules of engagement are, and both Sam and Robert have taken us through a good number of them, are contained in the Arbitration Act, although also, of course, within the arbitration agreement entered into by the parties. And there are a vast number of those sections of the Arbitration Act which the parties are permitted to state do not apply. There aren't that many, therefore, in that Arbitration Act, which, if you like, override any agreement. In fact, it can be said it's a sort of masterpiece of clarity and brevity. It stood the test of time. Perhaps no better illustrated than the fact that Scotland introduced its own Arbitration Act in 2010. Frankly, it's almost word by word the same act. So a couple of thoughts on arbitration. You've heard Robert go through the powers of the court. I described it as the muscle that can be brought in. Frankly, I think one has got to underline that arbitration is an excellent means of resolving disputes where both parties are keen for a swift result and they both are efficiently represented. If one side's not playing ball, consistently late in complying with the arbitration timetable, or is not being compliant with the process as a whole, then Robert's presentation has shown that whilst there is a mechanism for bringing in the heavy mob in the form of the court, that's not a process that fits with the model of a quick, cheap, and efficient means of resolving a dispute. But in circumstances where both parties are willing and keen participants, then arbitration is an excellent way of resolving disputes. Example, all the downsides to CPR are cast aside. Court diaries and unhelpful bureaucratic red tape just don't feature. The parties are not the servants of the court and or of the court process. Rather, the arbitrator serves the parties in their desire for a timeless and just outcome to their dispute. And then finally, a combination of a streamlined procedure and agreeing the arbitrator's fees up front will produce a very significant saving in costs. So that said, just two quick thoughts. Form of arbitration. And for obvious reasons, arbitrations which are conducted on paper rather than by oral hearing will be cheaper and quicker. And for that reason, they're a good fit for low value claims. Some of you may feel a sort of underlying concern that your case won't have the weight that it would otherwise have if the matter proceeded by way of an oral hearing. The answer, I would suggest, at least from an arbitrator's viewpoint, is that it's rare for a case to be determined principally on the live evidence of one party or the other. The objective evidence by which, for example, in an RTA case, I'd be thinking of the accident locus, the police evidence, independent witness evidence, the hospital records, the GP records. Those are the sources of the evidence which most often provide the strongest signposts to the case outcome. The context of the evidence of each of the parties lies in the extent to which their evidence comports with or doesn't comport with the objective evidence. But in any event, where an arbitration scheme does provide for an on-paper determination, then provision can also be made for a determination by oral evidence in the event that either party isn't content with the on-paper determination. That's so in the MIB untraced drivers agreement, and for that matter, in the 39 Essex arbitration scheme. So if you're not happy with the decision on the papers, there's provision for oral evidence. So those are the thoughts which I would leave with you as to the arbitration process. I've done now literally hundreds of arbitrations under the MIB untraced drivers agreement, and it works. So after those thoughts, I'm going to hand back to Robert to talk about electronic bundles.
Thank you very much, Colin. what I'm going to be doing now is something rather different. This is not going to be a talk in the conventional sense with slides, but rather a practical on-screen demonstration about the basics of preparing a reasonable quality electronic bundle. It is of note that the courts and tribunals are obviously using electronic bundles a lot now. We have experience in chambers of a vast range of different forums setting down rules and orders as to the structure of those electronic bundles. Frustratingly, those are not consistent with each other. And for example, the county courts are not necessarily consistent with the High Court, and indeed one division of the High Court is not necessarily consistent with another division. But what I'm going to cover in the next 10 or 15 minutes should cover the basics of dealing with most of what is being requested by courts and tribunals in relation to electronic bundles. So you should see on my screen a window setting out some files on my computer. Now I am using a Mac rather than Windows, but the software I'm going to be demonstrating shortly, Adobe Acrobat Pro, its appearance is almost identical across Windows and Macs. So you won't, as it were, be lost in the slightly eccentric nature of the way that Macs work. But just starting, here is obviously very simple 4 documents that I want to put into an e-bundle, and the standard format for e-bundles is PDFs. And you'll notice that one of those documents is a Word document and not a PDF. So the first thing we need to do is to open this file up in Word and convert it to a PDF. So here is the file open in Microsoft Word, and the way of dealing with this is very straightforward. There are other ways of doing this, but this should be relatively straightforward to most people. We just do a file and save as if we were going to save a copy of the document, but rather than formatting it as a Word document, which is obviously the default position in Word, we can save it as a PDF. We click on Export, and one would normally save it, but I've actually put myself somewhat ahead of the curve, and I've already done that. So we can now move back to the folder, and we now have 3 PDFs, including the stable, which is in a Word format, that we want to put into our bundle. So what we need to do is open all of the documents in Adobe Reader, and if we, Adobe Pro rather, and here you will see this is the first document, the bundle index, but across at the top here we can see different tabs containing the various different documents that we want in our bundle. Now, I should make a point here. The program I'm using is called Acrobat Pro DC. Many of you will be familiar with Adobe Acrobat Reader, which is a free program. Most of what I'm going to demonstrate can, in theory, be done on the free version of Adobe Reader, but it works in a very different way. What I'm going to do takes place on my computer. If you use the free version, the documents that you're working on will be uploaded into the cloud in some unknown server operated by Adobe and operated on there. And I'm sure I don't need to tell you that for various confidentiality, security, and GDPR reasons, that may be not what you want. So regrettably, we are forced to use the paid version of Acrobat to deal with this. So I'm going to be working with these icons down the right-hand side of the screen. Sometimes they may be hidden like that, or even hidden like that, so they're not visible at all. But there'll always be this little tiny arrow on the left-hand side of the screen, which allows you to bring that back. So let's go and have a look, first of all, at the Arbitration Act, which I've got here. And I'm just going to do a search in here. Sorry, no, not at all. Yes, I'm going to do a search in here, and I'm going to look for the word temporal. And there you can see it's found it in the recital to the Act. Now, if I switch tabs and go over to the statement of Ms. Innocent, and I'm going to do another search, and I'm going to search for driver in her statement. And you see we get this window here, this alert that this is a scanned PDF and cannot be searched. And so I'm going to show you what we can do about that. So we want to go down to this icon here, scan and OCR. OCR stands for optical character recognition, and that's what we're going to do there. And when we click on that icon, we get this additional window at the top here, and there we have recognize text, and we just click on in this file, and click on recognize text here, and you'll see a little progress bar down the bottom of the screen as Adobe works through this document. And now that it's done that, it's important that we save the file so we don't lose those changes, and we can close that window there. And if I do a search on driver now, you will find that it's found it in the body of the text. And that means that our document is searchable, and if the other documents are not searchable, we can do the same process with them because that is something which the courts find extremely useful. And indeed, if you are doing a hearing or you're instructing somebody else to do a hearing, providing them with a searchable bundle makes life a whole lot easier. Now, the next thing is we do not want to present to our tribunal a series of separate documents. We want a single unified bundle. Sorry, I've just had a bit of an issue. I can't say series very loudly without launching Siri on my computer. So I'm sorry if I dropped out there for a moment. But anyway, we want to combine these files into a single document. So we click on here, combine files. And because we've got all of our files that we want to combine open in Adobe Acrobat, we can just click on Add Open Files and then click Add Files. And then we have this window here, which shows the documents that we're going to combine. And we have the index, the statement, and the Arbitration Act. And if we want, we can move the order just by dragging them around the screen. We can change the order of the document so that they're in the order we want. So we want them to be index first, statement, and then the authority at the end. And once we've got them in the order we want, we just click on Combine, and they're all combined into one bundle. Now, at this stage, we've got a single bundle, which is 82 pages long, but it hasn't been saved. This is a new document, so we will save that, and I'm going to give it the name bundle. So I've now saved my bundle, and I have a single bundle. I can now click on these other documents, close them down because I've now got my bundle. The next thing we need to do, though, is to put some page numbers on this bundle so that people can work their way through the bundle. So we're going to use this icon here, Edit PDF, and that brings up this extra menu at the top here. And what we want to do is to click on Header and Footer and add that to the document. And this is the window that we get up. Now, I like to make my page numbers very clear and visible. So I'm going to change the font here to Arial Bold. I'm going to change the size of the font to 18. And I'm going to use this, which is the color picker, to select a red font. So I've now set my font, and you'll see there are 4 boxes here. This is for the header, and these are for the footer, and you've got left, center, and right. I prefer, personally, to put my pages in the bottom right-hand corner, but of course you can put them anywhere you want. And so you just click in the part of the footer or header box that you want to use to position your page numbers, and you click on this button, Insert Page Number. You can see this little bit of code that's added here, but helpfully you can see down here what your page numbers are actually going to look like. And now we just click on OK, and the document briefly updates, and then we can close this edit menu, and now we can see at the bottom we have a neat page number at the bottom of the document pages. Now the next thing, and courts are assisted by this and requiring this, is to deal with bookmarks. So we want to come over to this side of the screen now. As ever, if the menu is hidden, there'll be a little arrow down here. You can open it up. And this is the bookmark icon. We click on that, and you will see that the 3 document names that we had for our 3 files have been imported for us already as bookmarks. And you can see there are the file names there. Obviously, we don't want this file name to appear on the document that goes to the court. I'm not sure that we would be helped by telling the court that we're not sure our statement is correct. So we can just, sorry, I should say, right-click on the bookmark name and type, click rename, and we can just delete all of this, and it just says statement of as innocent. And if you want to be really obsessive about it, you can delete the .pdf bit, so it just looks like a title like that. And of course, we can also add our own bookmarks. So if we go to page 16 of the bundle, we will have whatever immunity or competence, let's do with this, competence of tribunal on its own jurisdiction. So we go to the page that we want, we click on new bookmark, and we just type in competence there. Unfortunately, it has put it in a position which is out of sequence, so we can just drag it down to the bottom, and there we have our bookmark. And if we go back to the index, we can now jump into section 30 by clicking on this bookmark panel. Now, it is possible that when your tribunal opens up this file, they have the screen looking like this with no sign of the bookmarks, and they may not be sufficiently familiar with Acrobat to be able to find those bookmarks. But we can do this. We can go into File and choose Properties. That's the properties of the document. And there are a series of tabs across the top, and we want to select the Initial View tab. And this sets out what the document will look like when it's first opened by the reader. And under Navigation tab, we can select bookmarks panel and page, which means that whoever opens this document will automatically see the bookmarks down the side of the page. And we just click on OK to set that. Now, the last thing, and believe it or not, and it's frustrating to a certain extent, but some courts are insisting that the index page is clickable. In other words, that clicking on an item in the index jumps to the relevant page. It's a bit fiddly to do this, but I'm just going to briefly take you through it. So we go, sorry, I did that a bit too quickly. We go back to our edit PDF. And at the top here in the menu of options under edit, we've got this one, which is link. And we want to add or edit a web or document link. Now, what now happens is that we have the possibility of drawing a rectangle on the screen. So I'm just going to go with my mouse and just select this area of the screen there. And then it says create link, and we want to set the link type as invisible rectangle. Otherwise, we'll actually have visible rectangles where you've just drawn one, which will look messy. And we want the link action to go to a page. So we just click next, and then we scroll to the page we want to go to. So let's go to the first page of the witness statement, and we click on set link. And then we can do that again, add another link. We'll now highlight this part of the screen, keeping the same options, next, and now we want to go right on to page 4, which is where the Arbitration Act starts. Set link again. And now we can close that and again save the document. And now if I click on Arbitration Act, we jump directly to the relevant page. And there's just one final thing that I want to show you, which I think is quite useful. For reasons that become obvious, it won't actually do anything on this document, but the process is worth understanding. So I'm going to go to More Tools at the bottom here. And I'm going to scroll down the screen to get to this, which is Optimize PDF. And I'm going to click on that. And you'll see at the top here, there is an option called Reduce File Size. So I just click on that, and it will ask me to save the document with a new name. So I'm going to call it Final Bundle, and click on Save. And it's working at the bottom. And it didn't work the last time I did it. Well, there it is. It successfully reduced the PDF size from 1.9 megabytes to 1.15 megabytes. And obviously, when you're dealing with larger bundles, the ability to reduce the size of the document is helpful because that makes it easier to mail into the court or tribunal. And so that, as it were, is my little run through of how to put together an electronic bundle.
Well, thank you very much indeed, Robert. Well, that brings us to the end of this webinar. Thank you all very much for attending. Perhaps on your behalf, I may be permitted to thank both Sam and Robert for their interesting and instructive talks. Hopefully any mist enshrouding arbitration has been lifted, its huge benefits revealed, and that you feel encouraged to consider it as a means of resolving disputes. As for preparing electronic bundles, hopefully now you may see that they're not the fearsome animal they may have seemed, but you may, if anything like me, be relieved to hear that the recording of the webinar and the slides will be viewable through our website if anyone needs a little bit more time to absorb those, I'm bound to say, fascinating tour that Robert gave us. Alternatively, if you'd like any of those emailed to you, then either Beth Williams or Charlie Leppington will be very happy to do that for you. Do email any questions arising from this webinar. And finally, voting has now closed on my haircut.